Learning outcomes. After studying this module, you shall be able to know about the expert witness role in the court of law. You will able to learn about the methods of presentation in court of law. You will also learn the role of counsel. Introduction. The culmination of any document examiner's work on a case can be the presentation of findings at a deposition, at a preliminary hearing in a courtroom, or before a quasi-judicial board. This requires a thorough review of all documents submitted for examination, plus any paperwork generated during the actual examination and the preparation of the report. A review ensures that the forensic document examiner is prepared to suitably explain his or her work, the nature of the testing conducted, and the basis for the opinions to be offered. While there are no carved in stone rules concerning how to conduct a case review in preparation for court, there are some logical steps that should be taken. First, a review of the initial contact on the case should be conducted. This may have been a phone call, letter, or email from the submitting agent. The date of this initial contact can sometimes become important during a trial or reason that have nothing to do with forensic document examiner's examination. This contact information also should include the nature of the original request made of the document examiner, and in civil matters, the result of any conflict check. Next, a review of the evidence submitted and the examination conducted on the evidence should be completed. If the initial examination was made many months prior, it may be necessary to undertake at least a brief re-examination of the evidence to be comfortable with the material. If instrumental examination were performed, a review of these examination and their result should be made. The document examiner should review the basis behind the instrumental techniques used and how to properly explain these techniques and the result to the layperson. Excellent work can all go for naught if the forensic document examiner is unable to explain the examination in such a manner that the audience, that is the judge, jury, hearing officers, etc., can understand. When testifying a technique that is not a frequent topic of testimony of document examiner, some extensive review of the techniques is called for. The witness stand in a poor place to realize that you cannot remember why or how an instrumental techniques works. Since every detail of the forensic document examiner's report can be a source for a question during his or her testimony, any report issued in the case should be reviewed in detail. All observations reported plus the opinions expressed should be very familiar to the document examiner, so he or she can quickly and competently answer any question posed about them. This is also a good time to organize all the papers in the case folder. To avoid having a shuffle through many sheets of paper on the witness stand, place like documents together in the folder. For instance, paper clipping together all letters from submitter makes them easier to find if needed. The same is true for all notes prepared by document examiner during the examination. Finding specific types of documents in the folder can be made easier if the forensic document examiner uses color papers for notes instead of white papers. For instances, bench of notes could be in one color, telephone records in another, and so forth. Another approach is to put the documents into a 3-ring binder with dividers between different categories of documents. This has a somewhat more professional appearance than a file or folder full of loose sheets of a paper and avoids the embarrassment of dropping those sheets on the floor. Finally, if it has not already been done as a part of report preparation, the case should be evaluated to determine if a demonstrative exhibit like a chart or an electronic presentation should be made to help court to understand the examiner's opinion. If the forensic document examiner decides to proceed with the preparation of this demonstrative charts or exhibit, it should be prepared prior to the pre-trial conference so that it can be reviewed by the attorney. Next we have the conduct of witness. The techniques of giving evidence is of considerable importance in the work of document examiner. Without the ability to convince the court of his conclusions, all the work he has done previously will be wasted. A correct conclusion reached perfectly may be lost in the confusion of a situation which the examiner is not able to present his finding adequately. In contrast, a properly prepared performance, clearly presented and, if required, well illustrated, will convince the court of the validity of his conclusion. The aim should be not to proclaim the opinion as undeniable, giving no grounds for it other than the states of originator. Rather, the witness should argue the reasons in a logical, precise and convincing manner so that the judge and jury will be persuaded by the evidence and appreciate for themselves that the conclusion is justified. Next is the dress. The bearing of witness is of importance. The judge or jury will be impressed by what he says depending on his clarity and logic. But other factors such as appearance and dress may be ignored. A survey in the United States showed that most people expected the expert witness to be smartly and soberly dressed. Although there is now less uniformity in the dress and more attention is likely to be paid to what is said than to more superficial personal appearance, a lack of courtesy may be inferred from unsuitable attire. Next is manner of giving evidence. The evidence is essentially for the judge and the jury, not for the counsel calling it. So, the questions are best answered not to the counsel but to the jury or to the judge, as the latter will be writing down much of what is being said. Glance in his or her direction will indicate the speed at which the evidence should be given. The expert will be more appreciated by the jury if directs his evidence to them, and by observing their reception of his words, he will notice whether he is making himself clear. Next is the presentation method. The first step in the chart preparation is to choose the presentation method that will be used. This can take form of printed charts, overhead projector, transparencies, 35 mm slides or computer presentation programs and videos. The classic 35 mm slides have effectively been replaced by the use of electronic computer presentation methods. There are some factors that will help the forensic document examiner to decide which method will be more effective. What needs to be demonstrated? If the issue is a photocopy manipulation and the source document is available, then the transparencies and an overhead projector may be simplest presentation method. If you need to show the court how an instrumental technique works, a video of the equipment as it is being used is very helpful. Next is, what is courtroom layout like? If you want to use video, Is there enough space in the courtroom to do this? If this cannot be determined ahead of time, it is best to either plan on another method or have a backup plan available. Next, how much preparation time is available? No matter how effective a photographic chart might be, it does not require some time to prepare. If there is not adequate time, then an alternative method must be considered. Next, to whom is the presentation to be made? A one-on-one presentation to a judge or hearing officer may call for one form of presentation, while another may be better when presenting the material to a jury. Next is what equipment and skills are available to the document examiner. While a video may be desirable, the forensic document examiner may lack the required equipment or skills, making it necessary to contract out his assignment, a projector and screen. The court may not be equipped with the necessary projector and screen, making it necessary to rent an arranged setup prior to the testifying. Next is the content. The next step is the chart preparation process is selecting the content to be included. There are two approaches to chart content. One that was used in the earlier years of the profession involving the incorporating a large number of images in a single chart. This style of chart provided a great deal of information, but also it is difficult for the judge or jury to focus their attention on a specific characteristics given the amount detail present. A second style, which is more in favor today, involves simple illustrations with less detail. In some cases, multiple charts may be used, each clearly demonstrating one specific point or small number of characteristics. In a signature cases, the obvious decision is to make the question signature as one of the image on the chart. If there is more than one question signature, a decision has to be made about which signature to include if all of them are not to be presented. Where only a sampling can be included, it is important to select those that are most legible and at the same time representative of the group. This can be important in cases where only copies of the document were submitted. Some copies may be clearer than other. The forensic document examiner should be sure that any question signature selected for the chart is from a document that is actually going to be a part of the trial. Just because of 6 question documents were submitted to the document examiner does not necessarily mean that all 6 are going to be an issue in the trial. This is one of the issues that should be discussed in pre-trial conferences when selecting the known signatures to be included in the chart. It is wise to ensure that the samples you anticipate using will, in fact, to be introduced in the trial as genuine signature. A chart containing a signature that has not been accepted into evidence will not be allowed. A portion of no signature to be included should be those that are closest in date to the question signature. This will reflect the writer's habit on or about the date at issue. It is sometimes necessary to display a pattern of writing duration over a course of months or perhaps years. This may require a separate chart in which the genuine signature are presented chronologically. In some cases, it may be discovered that the question signature displays a specific unusual characteristic infrequently found in the known signatures. In such a case, it is good practice to include at least one such example. If the issue involves a typewriter or computer font. Example of the appropriate letters must be chosen, and it may be necessary to enlarge from considerably to show the relevant defect or characteristics. Likewise, it may be necessary to enlarge trash marks from photocopiers and computer printers. Often, the location of the trash mark relative to a page edge, a print printed from element, or a segment of text, it is important in the formation of the opinion, and care must be given to capture the surrounding area in any image placed into a chart. Now next is the role of counsel. To present the evidence to its best advantage in the adversarial context of the courts, the expert requires the cooperation of the counsel introducing the evidence. It is his job to maximize its effect for his own case, but if he knows that it is already accepted by the other side, he may simply ask what the conclusions are and leave it at that. Unfortunately, this practice may extend to those cases where there is contest and evidence in chief. The first testimony of the witness is not adequately presented. The attitude that is up to the expert merely to express his findings, and if opposition wishes to challenge them, they may, is not ideal way of presenting technical evidence, especially evidence on handwriting. Next is conferences. In order for a counsel introducing the testimony to do so in the most effective way, a conference with the expert is often helpful. There are many reasons for this. First, he can make it clear in a complicated case what parts of the evidence he will be referring to and in what order he will introduce them. Second, the expert can make clear the reasons for his conclusion and their strengths and weaknesses. He can indicate what he might reply to certain questions if they occur in a cross-examination. It is advantageous if his later answer to not surprise counsel calling him. A general discussion both of the principle involved in the particular examination and its specific significance details should ensure that both parties are on the same wavelength. Normally, even in criminal trials, the expert witness is able to be present in court to listen to any evidence that bears on his own and to the evidence of opposing experts. Whether and when expert is to attend is one point that can usually be cleared up in the conferences. Next is the cross-examination. The purpose of cross-examination will vary from case to case. In some, the whole of the evidence of the document examiner is contrary to the interest of the opposite side, and in others, only part of the evidence is in dispute. In other cases, the only point to be clarified is one that may have been marginal interest to the expert at the time of his examination. It is sometimes of value to the cross-examiner to emphasize a point already made in evidence in chief to make sure that it is appreciated by the judge or jury. Occasionally, further examination on these same or different documents are required, and these are requested in cross-examination. The difference most noticeable to the witness is that the question put in cross-examination are usually not as predictable as those in evidence in chief, while the later will follow a statement or report prepared by the expert, perhaps in a way agreed at a conference. Those put by opposing counsels will not be entirely anticipated, although the purpose may have been merely to clarify some points or to emphasize an uncertainty already expressed. It may also be discredited the witness or at least his conclusions in a debate or agreement, in a meeting or a social exchange. A view may be expressed that is hotly contested. In the courtroom, however, the expert witness is in public place, perhaps with the glare of media coverage. What he says to be noticed by more than a handful of people, perhaps reported at the length. In these circumstances, he is placed in a far more vulnerable position than another scientist presenting a paper at a meeting or symposium, and any mistake he made will be greater significance to his reputation. Such a mistake may be over a small detail rather than an important conclusion, but in adversely system it may be magnified out all proportion by cross-examining counsel. It is therefore of vital importance that the expert in the witness box be fully aware of all the aspects of his evidence and its background. Apart from answering question truthfully and accurately, he may need to foresee what the next question will be. Too much conceit in one reply may lead to further answer that reduces the strength of the evidence to a degree that does not represent the proper conclusion. It is not the sole objective of counsel cross-examination to elicit the truth, but to reduce the evidence to a position most favorable to his client's case. The witness, however, must keep to be truth, conceding a point if that gives greater accuracy than an earlier answer, but not bending to pressure if it does not. In normal argument or debate outside of a court or law, the bearing of the opponents will be of less importance than the points they make. In the witness box, however, the expert will be to a large extent judged by the demeanor. This is tested by the pressure of cross-examination. His attitude must be dignified, the courteous and polite, and he must fair but firm in his answer. Little is gained by trying to score off his opponent, even if the temptation to do so sometimes very great. In the long term run, a far better impression is given by the patient but authoritative dignity and then by an argumentative display. There are, however, occasions when firmness is necessary. A tactic employed by some counsels is to interpret an answer if it appears to be going the wrong way. If this is not stopped by the judge, the witness should make it clear that he will not be deflected from finishing his reply. A lack of respect on the part of counsel is the best treated with disband, but there are some times when it is better to make it clear that is not appropriate. The most important point for the witness to remember is that in such situation, a loss of temper is very damaging of his bearing. In most cases, however, the cross-examination of an expert witness is carried out along for more civilized line, and the evidence is tested by logical questioning about the methods employed in the examination and about the validity of his conclusion reached. From the point of view of the cross-examiner, there is a need to reduce evidential value of the testimony to a point where the judge or jury will regard it as unsound, unreliable, or even mistaken. If the conclusion is soundly based, the cross-examination is likely to fail, but it arises from inaccurate observation or reasoning. Effective questioning will expose this. From the point of view of the expert witness, cross-examination can be testing or merely time wasting. If the observation and conclusions are correct, the question will cover the ground already considered. A properly based conclusion will have already taken into account all the points that may have indicated an opposite result. or an expression of uncertainty. Clearly, if there are reasons for reconsideration, they may be accepted. Pride or stubbornness cannot be allowed to take precedence over an admission of an error. The task of cross-examining counsel is not easy. As a layperson, he needs to understand the methods of working of the expert, his techniques, his findings and his deductions. He may be assisted by an expert of his own who may not or may agree with the findings of the witness. Little is gained by personal attack, which rarely impress, or even by an appearance or by even appearance or incomprehension which may not be shared by listeners. A better and more effective attack is by careful consideration of the qualification of the expert and the observation and deliberation that led to the conclusion. An erroneous opinion will be difficult to maintain if the questions are properly directed to this issue, but can left unsnatched if these are only challenged in one based on integrity of the witness. Now let us recall what we have learned in this module. A review ensures that forensic document examiner is prepared to suitably explain his or her work and the nature of the testing conducted and the basis of his opinion to be offered. If the document examiner decides to proceed with the preparation of his demonstrative exhibit, it should be prepared prior to the pre-trial conference so that it can be reviewed by the attorney. In a signature case, the obvious decision is to include the questioned signature as one of the image on the chart. If there is more than one questioned signature, a decision has to be made about which signature to include if all of them are not to be presented. It is sometimes of value to the cross-examiner to emphasize a point already made in the evidence in chief to make sure that it is appreciated by judge or jury. From the point of view of the cross-examiner, there is a need to reduce the evidential value of the testimony to a point where the judge or jury will regard it as unsound, unreliable or even mistaken. Thank you.